Well, good late morning, everyone. Thank you for joining. This is our Association Insurance 201. I appreciate everybody spending a little time on this Tuesday to learn about some insurance issues that we see relatively often in our practice. My name is Greg Godkin. I'm a shareholder here at RMWBH, and I actually head the litigation section for the firm, obviously working with the POA section on a regular basis as well. Because I have some litigation experience in dealing with these issues, I'm going to try to cover some of that of what we're going to discuss today from a litigation perspective. The idea being to avoid litigation if we can so do so. A lot of what we're going to cover today is relatively complex, and we see these issues arise on a pretty regular basis. This is why we've had a lot of requests for the presentation of an association insurance webinar. So if you didn't make the first one, it's available for you. It's posted, but we're going to go into Association 201 and cover some other areas. Before we get started, it's important that I read this disclaimer. The information presented today is based on the law as it exists of November 15, 2022. The information presented is for educational purposes and does not constitute legal advice. If you need legal advice relating to any of the topics discussed, please consult your attorney. So, what are we going to discuss today? Statutory requirements related to insurance, insurance policy basics. Excuse me, I apologize. This was covered in the first one. Statutory requirements, insurance policy basics, property coverage amounts, and name, store, and deductible. What we're going to cover today is a little different. We're going to cover some claims, reserve study, responsibility for maintenance, hoarders, and other laws. And I know that's pretty broad and covers a lot of topics, but I think you'll find that they all kind of meld together in what we're going to discuss. So first and foremost, insurance. I cannot emphasize enough to the folks joining today how much insurance plays into my practice on a regular basis. It probably touches on, as it relates to our POA work, I would say 75%. At some point with almost every association, any particular year, there's an insurance question. There's an insurance problem. There's an insurance concern. We're using insurance. It is an area that is often misunderstood, and I frankly get it. I've been doing this for 25 years this month, actually, and I've been involved in insurance law and how insurance applies to lawsuits since the beginning of my career. I'm by no means an expert. I don't know if it's kind of like golf. You may be better than others, but you're never going to master the game. It's sort of like insurance when it comes to POA law. There's some certain pitfalls that we see on a regular basis, and that's kind of what we want to talk about today. You may not know how to necessarily deal with the pitfalls just by attending this webinar. What I'm hoping you're going to get, what you're going to gain from this, is that you're going to recognize them. You're going to recognize this is an area that, hey, I remember that webinar we need to be careful about, and reach out to your attorney to deal with specifics, specific questions. That's really the goal of this webinar. You're going to recognize some areas. You're going to kind of recognize where you generally go with them, but understanding that every case is different, every claim is different. And so just recognizing that alone, you've learned a whole lot from the webinar. In dealing with condos in particular, it can be relatively complicated. For an insurance policy related to a condo, each owner is an insured, meaning that each unit is actually insured under the overall policy. And in addition, this is very unique. The insurer waives its right to subrogation against an owner. A lot of you may be asking, what is subrogation? Subrogation is the right of an insurance company to go after the party, the tortfeasor, the party that caused the damage, to essentially recover what it paid to the insured. So say, for example, I'm driving, a car runs a red light, hits my car, and there is no insurance by that driver. My insurance is going to pay for it as an uninsured motorist. They're going to pay me. They're going to fix my car. They're going to cover any personal injuries that I may have. So I'm made whole. The insurance company then goes in what's called subrogation. It subrogates against the tortfeasor, the party that actually ran into my car. They can even go so far as to file a lawsuit and attempt to recover what they paid out under my insurance policy. Not to make this even more complex than it already is, there's also some areas in there. Okay, well, when that happens, what happens with the deductible? Say I had $1,000 deductible, and they recover, they only recover $1,000. Do I get all the money to recover my deductible, or is it on a pro rata basis? And I hate to go to the lawyer answer that you hear more often than not. It just depends. It depends on what the policy says. It depends on if there are statutes that are applicable. But as it relates to insurance condos, um, the insurer cannot go after an owner for what it pays out under a condominium policy. Also, insurance policies state that related to condos that no action of an owner shall void the policy or be a condition to recover under the policy. Basically, you can't have an owner, even though an insured, to essentially control the policy. That is done on behalf of the association. And it kind of brings up the next point that all insurance policies related to condominiums provide that the association's insurance is primary to the owners. Primary meaning it's first. Before any other policy comes into play, that you're going to have the association's insurance policy, which is covering each owner as well, association property as well as each owner's condo, and it's going to be primary. It's going to be first. What happens when you have a claim? Well, we see this a lot. There's often a lot of confusion, whether it be a claim related to a broken pipe, a wind event, a fire, what have you. Claims, so an owner's, you may have only 2 or 3 of the units that are impacted, and say 100-unit condominium complex. Well, who's going to control that? Oftentimes the owner say, we want to control it. I want my folks in there, what have you. This is how it works. The claims are adjusted by the association. You have to have someone essentially running the show. It is the association. In addition, proceeds are payable to an insurance trustee designated by the association or to the association. I can't tell you how many lawsuits we see after, say, for example, a flooding event throughout Houston. We saw it during the winter storm, tons of it. The amount of confusion that comes into play with what happens to the insurance money, how is it distributed out, what have you. Keeping in mind that you have the fiduciary duty obligations unrelated to condominiums that come into play. So the number of lawsuits that we see come in where an association doesn't understand exactly how these proceeds are to be distributed out, how they're supposed to be used, gives rise to a ton of litigation. If they had simply been able to meet with an attorney to discuss what is required on how these funds are to be distributed, so much of this litigation should be avoided. Again, that's the point of this webinar. Recognize that this is a huge potential pitfall. Get ahead of it before it becomes a big lawsuit that goes on for 18 months and spends a whole bunch of insurance money and association money. The trustee or the association on behalf of the money holds proceeds in trust for the owner and lien holder. That's what I was just saying is critically important. This money is being held in trust for the owner. With that comes a lot of responsibility. I've seen this allegation come up a lot. Most of the time, it doesn't have validity. Unfortunately, sometimes it does, where you have an insurance company go and they pay out, say, for example, on a pipe bursting or the winter storm claims or flooding, what have you. Well, when the money is getting distributed for the owners, there appears to be some favoritism The board members' units are getting done first. Maybe there's some alleged betterment, that sort of thing. I cannot emphasize enough. Really having someone independent handle the money is probably best because you're going to forego a lot of those allegations, whether they have merit or not. You're still ultimately out defending them. This actually sets out how the money is supposed to be distributed in the event of a payment by an insurance company for a claim. Proceeds are dispersed first for repair to common elements and units. And owners and lien holders are not entitled to any portion unless there's a surplus after complete repair or restoration or condominium is terminated. So what this essentially means is if there's a surplus after everyone else is made whole, then it's distributed out to the lien owners and owners, lien owners like the mortgage companies. I can tell you typically that doesn't happen. Oftentimes it's, there's not going to be a surplus, but that is the rule nonetheless. Also related to condominium insurance. Insurance policy issued to association does not prevent the owner from obtaining insurance for the owner's own benefit. In fact, it may be required by the declaration. It's frankly good business sense and common sense that an owner have their own policy. And again, it's going to be not going to be primary, it's going to be secondary, and there will be some overlap. But it's better to have more insurance than not enough. And oftentimes it may be a situation where there's not enough insurance coverage. We're going to get into how to avoid that here later on in the webinar, but it happens. It frankly happens. And so encouraging owners to have their own secondary policies covering their units makes good sense. And again, some of the governing documents actually require it. Also, an insurer may not cancel or refuse to renew less than 30 days after written notice of proposed cancellation or non-renewal that's been mailed to the association. Getting these policies into place take time. You're making sure that you have adequate insurance, that you are, how much do we get? Again, we're going to cover a little bit more of that in the future. What you don't want to have is a situation where an association is told in a very short period there's not going to be a renewal, and everybody's scrambling. And so that's what is covered in this regard. All right, potential responsibility for deductibles. Again, this is an area that is in litigation. We see a lot of confusion. We see a lot of lawsuits come out of that confusion. What ultimately happens with a deductible? Some of these deductibles can be pretty extreme when you're talking about, for example, large condominium complexes where you have roofs, for example, and roof deductibles are a whole other complexity. There's also like issues related to, after a certain period of time, the deductible increases, what have you. Again, it gets very, very complex. In general, when the costs are less than the deductible, and this is in the event that it's an owner caused damage, that something happened where the owner is responsible. Maybe they didn't cause it, so to speak, but it's on their watch, so like a broken pipe in that owner's unit. The party that, i.e. the owner, is responsible for the damage. That only makes sense, right? You're not going to even get to the deductible. The owner is going to be responsible for that. Now, if the costs exceed or greater than the deductible, you're going to look at the dedicatory instruments to decide responsibility. And there's potential resolution to assignment of the deductibles as well. So you're going to look and see what are the governing documents say about who is responsible, and the costs are going to exceed the deductible. Is the owner going to be on the hook? Now, if the dedicatory instrument is silent, then the board can decide by resolution under TUCA 82111 and make it retroactive. Now, this is critically important. The resolution must be recorded as a dedicatory instrument in the real property records under TPC 202006. Okay, If the damage is caused wholly or partly by an act or omission of any unit owner, guest, or invitee, then the association may assess deductible and any other expense in excess of insurance proceeds against an owner and owner's unit. Now, this is when you're getting into some pretty large losses. This can come into play. Again, these are general statements. This is something when you get into these type of issues, I cannot emphasize enough, making sure that it's done right under the law, the governing documents, the applicable statutes, etc. You really need to make sure that someone is consulting with an attorney that has experience in this area. But in general terms, this is the rule. Now, pop quiz. You're not really gonna. You can just do it in your head. Honor system. Water leak in a unit above another unit causes damage to both units. The leak stems from a pipe in the upstairs unit, which only serves that unit. The repair costs are $50,000. The deductible is $5,000. Who is responsible for first, the claim, second, the deductible, and three, betterment and improvement within the unit? All right, so what did we learn? Who's responsible for actually the claim itself? The association. Remember, the association is going to control the claim. They're going to be responsible for the claim. When money's paid, it goes to the trustee or to the association acting as a trustee for those funds. Now, who's responsible for the deductible? Well, here we have a deductible is $5,000 and the repair costs are $50,000. So the deductible the repair costs exceed the deductible. If it was a situation where there was only $3,000, what did we learn? The unit owner, right? The unit owner would be responsible because the deductible, the costs do not exceed the deductible. Here we don't have that situation. The deductible is $5,000, repair costs are $50,000. So who's going to be responsible for the deductible? Well, you got to go back and look and see it in the dedicatory instruments. Who's going to be responsible? Ultimately, most likely the owner will be. They can go back and get it. Betterments and improvements within the unit, that is going to be on the unit owner. So you've got to look at the association with has a policy regarding the deductible, or again, you can go back and pass that resolution and get it recorded and make the owner responsible for the deductible in that event. Now, this is what I was discussing earlier, the situation when there's not enough insurance. Unfortunately, we see this on a pretty regular basis. Board members are not in the business to essentially opine on the value, cost of repair, cost of replacements. It is something that is incredibly complex, in particular when you're dealing with large complexes, but it can even be on a very small complex. And this is not just, by the way, applicable to condominiums. This is any association, townhome, condominium, single family residence. So what do? We do what's called a reserve study. The purpose of a reserve study is to understand the cost to replace association assets. i.e., what your the assets with the association is responsible for. Understand the future maintenance obligation and costs. For example, roads, pool repairs, what it's going to cost to eventually resurface the basketball arena, what have you, and how much to save annually. Like how much do you want to make sure you're not having to do a special assessment? How much do we save annually to essentially cover these future costs? Secondary purpose to verify that all assets are insured and compare to the property policy. What you're really saying there is this: did someone really forget to notify the broker that, hey, we have a new dog park. There's a new area over here that we built a community center that no one ever told the broker, and so it may or may not be insured. I'm going to get into more of that later on how critical it is that you have ongoing communication, certainly on an annual basis with your insurance broker about your insurance needs. But the reserve studies are critical. And what it is you have people that are in the business to come in and tell the association, the board members, hey, look, this is what we believe that it's going to cost to perform maintenance and repair on the road, to make sure that that is the value of that is going to need to be at X value for the purposes of insurability, insurance call, how much you're going to insure it for. Now, responsibility for maintenance. And that we're not going to cover a whole lot here because it's just only how it really plays in. For single family subdivision POAs, associations are responsible for common areas, like including landscaping, things that they must be maintained. And again, on the reserve study, talking about how much is this maintenance going to cost. There's a big difference between maintaining private roads and replacing private roads. Maintaining will certainly keep you from having to replace sooner than later, but ultimately some of this stuff will have to be replaced. Again, talking about things like anything with a motor, any pool equipment, fountains, that sort of thing. These are things that when put in, they're going to have maintenance costs and ultimately are going to have to be replaced over time. Nothing lasts forever, right? And these reserve studies will come in and basically it's enabling an association to be able to properly budget where you don't have that, oh my gosh, I never saw this $50,000 charge coming. And all of a sudden it's a special assessment to deal with it. That's why it's so critical to have these reserve studies. On single family POAs, of course, what is the owner responsible for? Their home maintenance, lot maintenance. Now, one of the things that was brought up, excuse me, in our last webinar on this is talking about, how do we, other ways to deal with a homeowner that is not fulfilling their contractual obligations for maintenance. Because that really is what it is. They move into these deed restricted communities. They have certain responsibilities that are theirs, i.e. yard maintenance, that sort of thing. What can an association do? Well, you consider self-help measures, basically force mows, that sort of thing. It really opens up a whole other webinar on making sure things are done right, that things are being documented properly, that if you're going to charge back that owner for that self-help mechanism, that's being done right. But again, it's a whole other area that we could spend an entire hour on. We're not going to spend a day, but it is worth mentioning that is an available remedy, depending on the governing documents, if it's allowed for. All right, so maintenance issues related to townhomes. I see often, the POA sees it on a very regular basis. What is a townhome versus a condominium? There's a certain set of understanding rules on what is a townhome versus condominium. Really, you look at how is it dedicated out in the governing documents, that sort of thing. But oftentimes it's people call it one versus the other, and it's just flat wrong. So you want to really make sure it's a townhome, because you're going to have some different responsibilities for a townhome versus a condominium. For example, the association's responsibilities for a townhome, common areas, landscape of owner lots. There may be an obligation for the landscaping of owner lots that you may not see in a condominium versus a single family residence. Possible exterior maintenance. Does that have to be maintained? Also about what in terms of upgrades and et cetera. Look, this is getting into the minutia details. Again, looking to counsel when issues arise about questions of, is it even a town versus condominium? What is the association's responsibilities? Making sure, again, a reserve study is done, but a reserve study can only opine to an association what is ultimately their responsibility first. From there, come up with a dollar value, right? So any questions that come up in that regard, you're encouraged to reach out to counsel to make sure that you're getting those answered before an issue arises. On the townhome, again, a lot of times you're going to have some unique um, maintenance requirements for owners that you wouldn't necessarily see in single family residence or condominium. Possible exterior maintenance. Um, there's there. Watch out for doors, windows, and hardware. Um, it's kind of a running joke that there are certain areas that we see all the time come up. And the uniformity is really important, right? Uniformity is really important when you're looking at condominiums and even townhomes. Oftentimes you'll see an owner, that they want to put in their own. I want to put in my own hardware on the windows and doors, what have you. Again, want to make sure that you're looking at the governing documents and the rules of the community on what needs to be done in terms of maintenance and for owner responsibility, but also making sure that they're following the uniformity requirements. And again, you would have to get into minutia and details of every particular association for specific questions. But the idea is to understand these issues do come up. It's the red flag to have you delve in a little bit more. And again, reach out to counsel if you have any specific questions about owner association responsibilities for townhomes. Condominium associations, who's responsible for what? You look at the governing documents, they assign responsibility, the bylaws, declarations, TUCA, and specific board resolutions. It says here, every unit owner should have a Texas condominium owner's insurance policy, even if they're renting the unit. We talked about this a little bit earlier. Encouraging, and again, some governing documents require each unit owner to have their own insurance policy. Renters, oftentimes you see a condominium is not owner occupied, it's renter occupied. I cannot tell you how many times we have seen when an unfortunate event like a fire occurs, and that's when the renter learns for the first time that they didn't have insurance on their contents. They didn't have insurance on everything that they brought into that condominium, from the couch to the television to their clothes. And it is such an unfortunate circumstance. Every renter needs to have a Texas renter's policy. Now, again, that's not our job as board members to essentially do much more than recommending, but because most of the time you're not going to see a requirement. But some governing documents do. They do have a requirement. You have to look at them. But in the very least, letting renters know, hey, as a renter, you're going to have your own renter's policy. It's not going to be covered by the owners. We're going to talk more about this here in later on. Policy should be reviewed with personal agent regularly. That is an area that I cannot emphasize enough, and I'll speak to that more a little bit later. All right. Damage caused by owners. This is not just dealing with just the insurance issues where we talked about before, but and as it relates to, like, say, for example, an owner's responsibility for damage caused to others by owner owned, like pipes, for example, what have you, things they may have done. Maybe they left a bathtub running and it flooded the unit under it. This is really, I see this, I can't tell you enough. Gates, the number of gates that are run into by owners and their guests it's pretty amazing. I realize that we probably all should own a gate repair company because they're all very, very busy. I don't know why people run into gates as much as they do, but it's a pretty regular thing we see. And then the issue becomes of, well, I'm not paying for it. The gate wasn't opening all the way, or it closed on me all of a sudden. We're oftentimes asked to actually have to file a lawsuit. to seek the money. Most of the time, like the automobile policy will cover it, but it's not just cars and gates. I mean, there's all kinds of litany of things that can happen. An owner or their guest may tear up um, some park equipment or basketball goal or pools, what have you. Ultimately, if is a who's responsible? Well, the owner, the residents, the guests, invitees. Those are the people who are going to be responsible for it. And unlike a condo, and this is under regular, and this is going to be under a regular single family resident, there's no subrogation waiver. So you can go, the insurance company can go after them for the money that they paid to repair whatever particular thing was damaged. Okay, another pop quiz. The association has $1 million property policy and the clubhouse is just burned down. There's a 2% deductible. The cost to restore and rebuild is $1,500,000. First, does the association have adequate insurance? Number two, how much will the association and how much will the insurance carrier have to pay? Well, the first one's pretty easy. It has $1 million property policy and the clubhouse burned down and it's $1.5 million to rebuild. So no, the association does not have adequate insurance. They're short, not even getting to the deductible by $500,000. Again, the reserve study, making sure that the clubhouse was adequately insured for restore and rebuild. So it's short by $500,000. Then you have the 2% deductible. The 2% on $1 million is $20,000. So you're going to have $20,000 deductible, plus they're $500,000 short. The association's going to be on the hook for $520,000. You really would like to avoid that, right? Because what's going to happen? Special assessment. All right. This is a completely different area that I want to cover because we've been asked a lot in the last few months. I'm not exactly sure why. There's just a lot of associations and their management companies dealing with it. But we want to briefly cover it here in this presentation before I go on to the issues related to brokers and some other things I want to tell you that I see on a pretty regular basis dealing with the insurance claims. Hoarders. Hoarders are folks that are essentially not meeting their requirements to maintain condominium units, for example. And it's creating more than just a nuisance, it's creating a dangerous environment. You have situations where there's health safety issues. What can be done? All right, under TUCA, the association may enter for bona fide emergency purposes when conditions present an imminent risk of harm or damage to the common elements, another unit, or the occupants. Okay, this is the ultimate self-help measure, right? You're actually entering the premises of another. I cannot emphasize enough to you guys that obviously if this is a real emergency, and I call it a dire emergency, that you can enter to deal with a bona fide emergency. I don't recommend it unless it's an absolute last resort. This is really where you want to have your 911 involved, right? You want to have police, fire, EMS. We've had situations where there has been bona fide emergencies. Allegations are made that things were stolen, that sort of thing. I'm not saying in the event of something being imminent, you don't go in if it's to save a life, to deal with something that is truly about to cause, and this is what is so critical, imminent risk of harm or damage, okay? Imminent meaning it is going to happen any second unless we go in and do something. Otherwise, don't do it. Just do not do it. It is not worth the risk. And frankly, going in anytime you're going to go into someone's residence, there's, you know, let's just say that the way the world is these days, um, there are some bad things that could happen. And so really leave it to the professionals, those with training, unless someone feels it is truly to what my personal opinion, if it's not to essentially save a life, the place is about to burn down, it's that sort of thing, don't do it. It's just not worth the risk. But under TUCA, there is a right to do so, so long as you meet this criteria. Um, this is really dealing more of what level are we talking about in terms of hoarders, of folks that are creating health safety issues for the overall community. Um, there's things like nuisances. Well, I'm not mowing my, someone's not mowing their grass, and so as a result, there's an increase in varmint and mosquitoes, that sort of thing. That's really a nuisance. Hazards, by the way, this isn't, these aren't necessarily legal terms. I'm just telling you kind of how they're ramped up. Hazards to me are more of, all right, that is something that's more than just a, a situation where it's creating a problem with the mosquitoes and varmint. Hazards is someone's going to get hurt. There's something being done by an owner that is actually created a situation where someone's property or someone's person is in danger. And in those particular circumstances, look, it could be a litany of things. It could be a tree that has been struck by lightning and is hanging over a sidewalk. It could be a litany of things that can create a situation where someone's property or person could be hurt. Um, Fire risks, I think that definitely falls in the way of hazards or health concerns. I mean, are they doing something? Are they burning things, that sort of thing? This, and I know I'm speaking to the choir here. You guys see it every day. Um, Situations where an owner, for whatever reason, has created a health safety issue, but there are oftentimes ordinances that can be used, using every tool possible out there. Your attorneys, the management companies writing the cease and desist, ramping up to the attorneys and getting the city involved if it is getting to the point of being a hazard, high risk, a fire risk, or there's some health concerns. This is actually a City of Houston ordinance. Associations rely upon the government entity when possible. This is dealing with really more of mental health. We're seeing a lot of that. We're seeing um, issues related to of folks that are struggling with stress and frankly everything that's happened between the COVID and what have you. There's a lot of this that we're seeing, substance abuse, that sort of deal. It it becomes a challenge, right? Of we're here to govern the overall community, but we're not here to essentially um, be the person or excuse me, it's not the board's role to essentially quote unquote take care of people. So there is a fine line there, but obviously reaching out to those that can help is something that the professionals is something that we certainly recommend. Oftentimes there's situations where people are in dire need and there's no one else. And so again, I'm going to say all this with a caveat. Um, I didn't write the laws. My job is to make sure my clients are following them and using the law to our advantage to deal with folks that are not following the law. Okay. Um, the law is somewhat quirky in that oftentimes thing comes down to duty. Do you have a duty? You have a legal duty to do something? Well, oftentimes the answer is no, until you take something else, until you take something on. Once you take on an obligation, then now you have a duty to do it in a manner as a reasonable person or a reasonable association would do it, what have you. You can literally open yourself up to liability if it's not done right, or even a lawsuit. If you think it was done right, doesn't mean you're not going to get sued. I'm not saying that it makes a lot of sense to walk around this world scared to do anything to help someone, because ultimately there may be an allegation you didn't do it right and cause more harm than good. That's just not how we work in society. But I am going to warn everyone on this call, if it gets into a situation where there may be some issues or related to disabilities and that sort of thing, I cannot emphasize enough that the management company, the association through its board, reach out to counsel that can give some advice to make sure that everyone is following all federal and state guidelines regarding reasonable accommodations and that sort of thing. Um, I could spend the next 3 days going over the nuances of what all that means. Again, our purpose on an hour webinar is just to recognize that issue and go, aha, maybe this is something we need to seek professional counsel about. Reach out to an attorney that has expertise in this to make sure that we're doing things right and we don't get ourselves in a pickle. Okay, quality of insurance. Um, if there's anything you take from this webinar, only one thing. I hope it's this: having an insurance broker that understands POAs, that understands the nuances that comes with condominiums, townhomes, single family residences, associations, um, directors and officers insurance, what it means to insure um, community property. I cannot emphasize enough how critical it is. This is not a knock on all brokers, but there are some out there that frankly don't understand what we all do. They don't understand the nuances of insuring master plan communities, condominiums, what it means to have good D&O insurance related to homeowners associations and condominium associations versus just a typical nonprofit. There are nuances that we deal with every day that frankly become old hat to us, that is a foreign language to those that don't live in our world. I have seen more times than I want to remember where an insurance broker has not properly insured a community. Having an insurance broker that understands this POAs is critical, and just as critical, making sure that that broker is kept well aware of any changes in that community. I've unfortunately seen circumstances where insurance is renewed in, say, February. In July, the association puts in a new swimming pool. Guess what? No one tells the broker. I don't know how this happens, but it happens. No one tells the broker. An unfortunate event occurs at the pool, and there's no insurance coverage. This sort of thing. I'm just using that as an example. I see it all the time, that a new community, there's new equipment that's put in. There's a change in the community, and really that's what this is: a change in the community that may require a change in insurance. That really is its key. a change in the community that may change the requirement for insurance, whether it be an increase. There's a new playground that has equipment that needs both general liability coverage and making sure that if somewhere catastrophic event, a wind event, whatever happens, a fire, that is covered. The open line of communication between your broker and the community is key. And I can also tell you this, if your broker should be every year at renewal, reaching out to you well in advance and asking these very important questions. And frankly, if it's a large community, probably going out there and looking at it. But in the very least, there needs to be some meetings. And I'm not talking about 72 hours before the renewal check needs to be, the documents need to be signed and the check needs to be sent. This needs to be well in advance. Um, I I so often find myself in a situation of having to explain to a board that they don't have coverage for this particular event. And to say that I see shock on their faces is an understatement. And frankly, you know, I'm going to fight the same whether I'm getting paid by an insurance company or I'm hired directly. But the difference is who's paying me to do that? Who's paying me to fight? And most importantly, if there has to be a check written at the end of the day for a liability, or God forbid there's a catastrophic event, a fire or something, or freeze, and you find out that, oh, no one ever got that covered by insurance, or, well, when it was insured 7 years ago, it was insured for X. Never mind that the cost of labor and materials is 6 times what it was then. So it's like the sort of situation earlier, the clubhouse, right? It was $1.5 million to repair it or replace it. We only had $1 million in insurance. You got to avoid this, get ahead of the game. And I just cannot emphasize doing this enough. This open line of communication with a broker that understands what it means to insure condominiums, townhomes, to provide insurance for associations of master planned communities is absolutely critical. And there's some good ones out there. And to the extent that you guys would like, we don't endorse any particular broker, but I can tell you some that certainly we've had good relationships with. I'm happy to do so. Which brings up another issue that I meant to bring up at the very beginning. I know we've gotten some questions throughout the webinar. I will never have enough time to answer them properly. So what we like to do is we'll put them all together, and then someone will provide answers to all those questions that have been set out. Okay, in conclusion, I think you've gotten my point. I hope making sure you have proper insurance. Understand the responsibility of maintenance versus insurance obligations. Recording a resolution regarding deductibles. That's also a critical issue that we learned about and how that can be done. Using TUCA restrictions and local laws to understand rights and obligations of everything from dealing with insurance to dealing with hoarders. Reaching out to an association's attorney and broker, insurance agent, broker on coverage and questions regarding the same, and to make sure you have the right broker and insurance company. How critical all these things are in the event that we've got to actually use the insurance that we've been paying premiums for. So I want to thank everybody for joining. I know, again, we did get a number of questions, and we will be reaching back out to provide those. I hope everybody got something from this webinar, and I hope everybody has a wonderful Thanksgiving and upcoming holiday season. We'll be doing another webinar soon, and also look, if there's particular areas you guys wish to cover, put it in the chat, and we'll take that into account. We want to make sure we're giving you the webinars that you guys feel are most helpful. And with that, I want to thank everybody again and hope everyone has a great day. Thank you, Jack. I appreciate that. Take care.